This bill is making the rounds online, not surprisingly, because a lot of people are concerned that it's a continuation of the government encroaching on civil liberties using the COVID-19 pandemic as the reason to do so. I will say, though, it was introduced several years ago for the first time. Take a look at this. Assembly Bill A416 relates to the removal of cases, contacts, and carriers of communicable diseases who are potentially dangerous to the public health. Versions introduced in other legislative sessions right here, 2015 to 2016, 2017 to 2018, 2019 to 2020, and now. So this is not new, but I think it's getting a lot of attention because people are saying, well, maybe they didn't take it as seriously before, and now they are, as they've seen really historic government control mechanisms for this particular pandemic. Not to say that there haven't been government control mechanisms in decades past, but at least in my lifetime, this is pretty historic. This is the most I've seen. Perhaps you could argue that maybe the Patriot Act, right, had its own problems in that regard, but for different reasons, but still used, as kind of like the reasoning was for public safety, right? So there are a lot of people talking about this. I want to go through it line by line. Nick Perry did respond to concern over the bill in a statement that he posted on Twitter, so I'm going to read you that before we get into the bill itself. It reads, to all those concerned about Bill A416 who do not have the background information, this bill was initially introduced to address public health concerns related to the containment of the Ebola virus after it was discovered that Ebola-infected persons had entered the United States. I am an American who understands our Constitution is sacred and provides us with the right to agree or disagree and hold different positions on issues that may relate to our civil and constitutional rights. There is no intent, no plan, or provisions in my bill to take away or violate any rights or liberties that all Americans are entitled to under our Constitution, either state or federal. A proper reading of the bill would find that significant attention was paid to protect individual rights, which could be affected by exercising the authority granted in this bill. Hey, you be the judge. I'm going to read you the bill. You be the judge as to whether you think that's the case. I urge you all to read the bill carefully and not accept grossly misinformed and misrepresented interpretations of this bill, even though some provisions in this bill may be applicable to the current COVID-19 pandemic. Bear in mind also that the Ebola virus raged through many African countries before it was contained and meant almost certain death to anyone who contracted the virus. Death rate up to 90% World Health Organization, he says. Okay, I have read the bill. I'm going to read it to you, but just FYI, like it says any communicable disease that is determined to be basically a public health emergency by the governor. So it doesn't just say Ebola. It says anything the governor determines to be a public health emergency, basically with communicable diseases. I am convinced that most smart Americans faced with the deadly consequences of having a person who is a carrier of a very deadly virus roaming freely through any community would support public action to contain such a person from contaminating and potentially bringing certain death to persons they have contact with. The bill hasn't been actively pushed for passage because the Ebola threat was ended thanks to a vaccine. However, many learned scientists believe that the likelihood of such a deadly pandemic is still real, and somewhere in the future, there may be the need for people to be protected from a person or persons carrying a very deadly and transmittable virus, and this bill is designed to ensure that our government could lawfully act to protect all the people. I am open to amendments that would address real concerns raised by critics and will quite happily accept suggestions that will improve the bill in regard to concerns to constitutional rights. I also pray for those who have called me names, including racial ones, made threats, and used words towards me which I would never use to describe any person. I ask God to bless them all and keep them safe. Assemblyman Nick Perry. So he says he's open to actual criticism and suggestions that would improve the bill. So hey, leave Mr. Perry a comment in the comment section if you feel like there should be changes to the bill. Again, we're going to go through this bill line by line, talk about what's in it. You can make a decision for yourself what you think about it. I will say I did pass this along to a medical doctor to just have him look it over and give me his thoughts as somebody who would say be put in a position to make a decision like this, that somebody's a public health risk. He's in, the medical field. And of course, you'll see in the bill that it may not necessarily be somebody in the, your physician, for instance. It appears like the Department of Health could be making these determinations. So he said that if you were to just objectively just look at everybody who could be a suspected public health risk and you were to detain all of them, there just would not be enough facilities to do so. So there's going to have to be some kind of subjective determination about who, not just from a public health standpoint, like you've got the virus and you're a health risk. There would have to be other protocol that you would determine somebody to be a risk. And what would those subjective factors be? Would it be that you're refusing to do what they say to ameliorate the situation? You'll see part of the bill says, hey, they can tell you have to go through a particular treatment program before they let you go. Are you refusing to stay in your house? Are you talking about it online? I mean, who knows what the determinations would be. But as he was saying, which makes sense, if you were to just, objectively take everybody that, say, with COVID-19 could be a carrier of COVID-19, could be infected with COVID-19, could be contagious, that there just isn't enough facilities to put everybody somewhere. And so who of those people are you going to decide need to be given sort of the strictest interpretation of this bill? How are you going to make those decisions? And I think when it comes to these kinds of legislative actions, that's a great question because, right, we're seeing that with the business shutdowns. Like, how are they making the decision that this one business is a super spreading business versus this other one? And we've seen how small businesses have really suffered compared to large corporations when it comes to this. And there are all kinds of fair questions to be asking about how these determinations are made. So the same thing could happen with people, right? Like, if you're going to decide that all of these people are a public health risk, you can't possibly detain them all. So what are your next criteria going to be that are going to green light the detainment of individuals or groups? But let's look at the bill and then leave me a comment in the comment section and let me know what you think about it, all right? So this is it, and I'm going to put a link to this in the description so you can read it for yourself. But let's go through it. It's the State of New York, 416, 2021, 2022, regular sessions in Assembly, pre-filed January 6, 2021. An act to amend the public health law in relation to the removal of cases, contacts, and carriers of communicable diseases who are potentially dangerous to the public health. Section 1. The public health law is amended by adding a new section. Removal and detention of cases, contacts, and carriers who are or may be a danger to public health. Other orders. 1. The provisions of this section shall be utilized in the event that the governor declares a state of health emergency due to an epidemic of any communicable disease. Okay, so that's how it starts. The governor declares a state of health emergency due to an epidemic of any communicable disease. That's kind of a wide swath of possibilities there. Think about when this could have been used. And again, like I told you, I guess originally this was introduced in regards to Ebola. Upon determining by clear and convincing evidence that the health of others is or may be endangered by a case, contact, or carrier, or suspected case, contact, or carrier of a contagious disease. So you may have it, or maybe you're suspected of having it. And so you're considered part of this. That in the opinion of the governor, once again, the governor has the power here, after consultation with the commissioner, may pose an imminent and significant threat to the public health resulting in severe morbidity or high mortality, the governor or his or her delegee, including but not limited to the commissioner or the heads of local health departments, may order the removal and or detention of such a person or of a group of such persons by issuing a single order identifying such persons either by name or by a reasonably specific description of the individuals or group being detained. Such person or group of persons shall be detained in a medical facility or other appropriate facility or premises designated by the governor or his or her delegee and complying with subdivision 5 of this section, which we'll get to. A person or group removed or detained by order of the governor or his or her delegee pursuant to subdivision 2 of this section shall be detained for such period and in such manner as the department may direct in accordance with this section. So again, just to go back to it, you're either going to be detained in a medical facility or whatever they determine to be an appropriate facility or premises. And that, again, designated by the governor or whoever the governor, gives that authority to, I guess, or whoever is considered authoritative as a delegee under the governor. This is where it starts to get interesting. because they talk about time, how long you could be detained, what kind of recourse you have, and the fact that they can force medical treatment on you. So it says, notwithstanding any inconsistent provision of this section, a confirmed case or a carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines that such a person is no longer contagious. So they determine for you, you're not contagious anymore, and you get to go. Here's the problem, like with the COVID pandemic, there is still a lot of mystery about when and how you're contagious. Even regarding the vaccine, they don't know if, even if you get the vaccine, you can be a carrier of the SARS-CoV-2 virus. So how they're going to determine for that person who is suspected or has a particular disease that they're no longer contagious, that's not something that's just like immediately known for especially novel viruses. B, a suspected case or suspected carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines with the exercise of due diligence that such person is not infected with or has not been exposed to such a disease, or if infected with or exposed to such a disease, no longer is or will become contagious. All right, so you could be exposed and maybe they think you're contagious, but then they're going to decide you're not. You know, maybe they say you don't have it anymore. Of course, we've seen issues with the COVID test. Like Elon Musk tweeted one time, right, that he had 4 of the same test, like rapid fire given to him by the same nurse, and 2 came up positive and 2 came up negative. So it just goes to show, like, again, the difficulty. And oftentimes when people push for this kind of stuff, which is, it's kind of a similar argument when people push for lockdown of information online, for instance, that, you know, lockdown of disinformation or harmful information, and don't realize how subjective those calls can be, which is, again, why I'm such a purist. I would rather take the risk in order to maintain important information that could go out, you know, the baby with the bathwater side. Like, that's why I'm such a purist on freedom of speech, because yeah, of course, you might get some crappy information and what some people would consider dangerous information, but what about the good stuff that would go out with it if all of a sudden subjectively we're to start determining what is dangerous information from, like, say, a government level, right? And so it's kind of similar here, that you could have people who are subjectively determining, for instance, like, you know, who is or who is not, as I said earlier, risk enough to be put in detainment. Let's continue reading, shall we? A person who is detained pursuant to subdivision 2 of this section as a contact of a confirmed case or a carrier shall not continue to be detained after the department determines that the person is not infected with the disease or that such contact no longer presents a potential danger to the health of others. A person who is detained pursuant to subdivision 2 of this section as a contact of a suspected case shall not continue to be detained after the department determines with the exercise of due diligence that the suspected case was not infected with such a disease or was not contagious at the time the contact was exposed to such individual. And this is basically talking about, like, you know, the contact tracing side of things. Okay, you were in contact with somebody who has this disease, so now you're a suspected case, so this is what we can do. And now they're saying, okay, we won't detain you under these circumstances. So continue reading. So that was number 1. This is number 2. After the department determines that the contact no longer presents a potential danger to the health of others. So they're going to once again determine whether you're a potential danger or not. A person who is detained pursuant to subdivision 2 of this section shall, as is appropriate to the circumstances, A, have his or her medical condition and needs assessed and addressed on a regular basis. So that's nice of them. If they detain you, they're going to make sure that they take care of your medical needs. Hopefully they feed you too and give you water. B, be detained in a manner that is consistent with recognized isolation and infection control principles in order to minimize the likelihood of transmission of infection to such person and to others. Now, number 6, when a person or group is ordered to, they say person or group, right? That's interesting. Like, they can take a whole group. Maybe that's a family. Is ordered to be detained pursuant to subdivision 2 of this section for a period not exceeding 3 business days, such person or member of such group shall, upon request, be afforded an opportunity to be heard. If a person or group detained pursuant to subdivision 2 of this section needs to be detained beyond 3 business days, they shall be provided with an additional commissioner's order pursuant to subdivisions 2 and 8 of this section. So they're saying that the beginning period's 3 days. 3 business days. And they can then decide to keep you longer. So then this is where they make that determination. So we're going to read that now, okay? All right. When a person or group is ordered to be detained pursuant to subdivision 2 of this section for a period exceeding 3 business days, and such person or member of such group requests release, the governor or his or her delegee shall make an application for a court order authorizing such detention within 3 business days after such request by the end of the first business day following such Saturday, Sunday, or legal holiday. So they don't have to work on the weekend, I guess, to keep you there. They can keep you longer if there is a holiday that they get to take off, which application shall include a request for an expedited hearing. After any such request for release, detention shall not continue for more than 5 business days in the absence of a court order authorizing detention. Notwithstanding the foregoing provisions, in no event shall any person be detained for more than 60 days without a court order authorizing such detention. So they can keep you longer than 60 days, but they need a court order. Full stop real fast. That's the thing. Like, it goes from 3 days to 60 days, and then they can keep you longer if they just get another court order. So where does this end? It appears, and I am no legal expert, but they could just continue getting court orders. And I'm not yet seeing that there is like an end date. Okay, there is an end when it comes to their determination that you're no longer a risk. But as far as like, hey, at a year, you're not a risk anymore. Okay, at a year, we will definitely let you go. I haven't seen that yet. I don't see it. The governor or his or her delegee shall seek further court review of such detention within 90 days following the initial court order authorizing detention, and thereafter within 90 days of each subsequent court review. So you can just continue having these court reviews, and then they have to act within 90 days. 90 days is a long time. In any court proceeding to enforce an order of the governor or his or her delegee for the removal or detention of a person or group issued pursuant to this subdivision, or for review of the continued detention of a person or group, the governor or his or her delegee shall prove the particularized circumstances constituting the necessity for such detention by clear and convincing evidence. And here's how they're going to notify you. A copy of any detention order of the governor or his or her delegee issued pursuant to subdivision 2 of this section shall be given to each detained individual. However, if the order applies to a group of individuals and it's impractical to provide individual copies, it may be posted in a conspicuous place in the detention premises. Any detention order of the commissioner issued pursuant to subdivision 2 of this section shall set forth. Okay, so now they're going to tell us what it says. It's going to have to say the purpose of the detention and the legal authority under which the order is issued, including the particular sections of this article or other law or regulation. A description of the circumstances and or behavior of the detained person or group constituting the basis for the issuance of the order. The less restrictive alternatives that were attempted and were unsuccessful, and or the less restrictive alternatives that were considered and rejected, and the reason such alternatives were rejected. Okay, I think this is really interesting. So basically what they're saying is, likely they're going to try to force you to stay in your house, or maybe they're going to force you to shut down your business or whatever, and you decide you're going to say, no, I'm defying your decision. So then they're like, well, I'm sorry, now we're going to forcibly detain you. Because we tried playing nice and you refused to do what we said. So now we have the ability to lock you down. That's what I read there. And again, that brings me back to the original point I was making when I was talking to this doctor about who is going to fall under the more severe interpretations of this. Sounds like dissidents, okay? Sounds like if you disobey, you're one of those people they're going to come to. Continuing on, it will also have to include a notice advising the person or group being detained that they have a right to request release from detention, and including instructions on how such request shall be made. So letting you know, hey, you can appeal. A notice advising the person or group being detained that they have a right to be represented by legal counsel, and that upon request of such person or group, access to counsel will be facilitated to the extent feasible under the circumstances. So it sounds like you get a defense attorney, because that's interesting. Like, is this considered to be like a crime in the sense that, okay, we're forcing you into detainment, so we also have to give you counsel? It sounds like the defense attorney system there, which makes this even more interesting because, of course, you may not have the means to obtain legal counsel if you can't afford it, right? So, I mean, I agree they should be giving you a lawyer if they're going to be doing this kind of stuff, but that just makes it even more of that tone that this is sort of a criminal, of a criminal nature. Like, you're being detained, not necessarily that you have committed any actual crimes, but that you're being treated as such because they're going to have to offer you legal counsel. That's what I see there. Continuing on, a notice advising the person or group being detained that they may supply the addresses and or telephone numbers of friends and or relatives to receive notification of the person's detention. So they're going to let your friends know and your family that, hey, you didn't come home for dinner tonight because the state picked you up and put you in some kind of facility to detain you, and that the department shall, at the detained person's request and to the extent feasible, provide notice to a reasonable number of such people that the person is being detained. So don't ask them to call 12 people. That's too much. Okay, it doesn't say that here, but they're going to determine what's reasonable for how many people they're going to call for you. In addition, an order issued pursuant to subdivisions 2 and 7 of this section requiring the detention of a person or group for a period exceeding 3 business days shall advise the person or group being detained that the detention shall not continue for more than 5 business days after a request for release has been made in the absence of a court order authorizing such detention. So they can keep you for 5 days if you've made a request to get out, unless they get a court order that forces you to stay. Advise the person or group being detained that whether or not they request release from detention, the governor or his or her delegee must obtain a court order authorizing detention within 60 days following the commencement of detention, and thereafter must further seek court review of the detention within 90 days of such court order and within 90 days of each subsequent court review. So we've sort of already talked about that part. And then advise the person or group being detained that they have the right to request that legal counsel be provided, that upon such request, counsel shall be provided if and to the extent possible under the circumstances, and that if counsel is so provided, that such counsel will be notified that the person or group has requested legal representation. A person who is detained in a medical facility or other appropriate facility or premises shall not conduct himself or herself in a disorderly manner, and shall not leave or attempt to leave such facility or premises until he or she is discharged pursuant to this section. So basically, you better behave, don't act out of line, and you better not try to leave. Because it's like Hotel California here. Where necessary and feasible under the circumstances, language interpreters and persons skilled in communicating with vision and hearing impaired individuals shall be provided. So they're going to try to get you a lawyer, and also they're going to try to get you an interpreter for a particular language, or if you're vision and hearing impaired, they're going to try. So to make sure you understand what they're talking about. And the provisions of this section shall not apply to the issuance of orders pursuant to this other part of the New York City Health Code, in addition to the removal or detention orders referred to in subdivision 2 of this section, and without affecting or limiting any other authority that the commissioner may otherwise have, the governor or his or her delegee may, in his or her discretion, issue and seek enforcement of any other orders that he or she determines are necessary or appropriate to prevent dissemination or transmission of contagious diseases or other illnesses that may pose a threat to the public health, including but not limited to, this is where it gets really interesting, folks, orders requiring any person or persons who are not in the custody of the department to be excluded, to remain isolated or quarantined at home or at a premises of such person's choice that is acceptable to the department and under such conditions and for such period as will prevent transmission of the contagious disease or other illnesses, to require the testing or medical examination of persons who may have been exposed to or infected by a contagious disease or who may have been exposed to or contaminated with dangerous amounts of radioactive materials or toxic chemicals, to require an individual who has been exposed to or infected by a contagious disease to complete an appropriate prescribed course of treatment, preventative medication, or vaccination, including directly observed therapy to treat the disease and follow infection control provisions for the disease, or to require an individual who has been contaminated with dangerous amounts of radioactive materials or toxic chemicals such that said individual may present a danger to others to undergo decontamination procedures deemed necessary by the department. Such person or persons shall upon request be afforded an opportunity to be heard, but the provisions of subdivisions 2 through 11 of this section shall not otherwise apply. All right, so they can tell you not only that you have to be detained, but while you're detained, that this is what you have to do medically in order to get out. And that could include being vaccinated. It can include taking some other kind of medicine. It's a pretty wide open field here. This is where it ends. This provisions of this section shall not be construed to permit or require the forcible administration of any medication without a prior court order. Okay. So unless they get a court order, they're not going to force medication on you. But they could get a court order that would say that. This act shall take effect on the 30th day after it shall have become law. Effective immediately, the addition, amendment, and or repeal of any rule or regulation necessary for the implementation of this act on its effective date are authorized to be made and completed on or before such date. So what do you think? Definitely want to hear from you all in the comment section. I got to say, there's a lot of sort of open language here that I think could be interpreted a lot of different ways. And then so I can understand why people are concerned about this. It's interesting that this has been introduced over multiple years and doesn't seem to be successfully passing. Will COVID make a difference for that? I don't know. It's definitely, I think, making a difference for the attention that it's getting. So will you have lawmakers push back on it because their constituents are now aware of this kind of stuff and are like, no, we don't want this? Or will you have people telling their legislators, I like this. I like this because I don't want Joe Smith, my neighbor, to be allowed to be around me if he is going to potentially endanger me with whatever his communicable disease is. I don't know. We'll see if we'll get more coverage of this in mainstream media too. Like I said, I haven't found a ton of it out there. I'm interested to know more. Maybe I'll call this assemblyman myself and see what he has to say. I wanted to get this online, so I figured I'd just read through it. I'm not a constitutional attorney, so I'm curious what a constitutional attorney would say about this too. So I'm going to make a few phone calls on that as well. So lots of questions here I have. Again, love to hear from you in the comments. Don't forget to like, share, subscribe, and there are links in the description for how you can support my work. And I'll see you all next time.